Hello, I'm Dr. Terry Susan Fine, Content Specialist for the Florida Joint Center for Citizenship, which is part of the School of Politics, Security, and International Affairs at the University of Central Florida in Orlando. Welcome to our Middle School Civics Highlights series. Today we focus on CG 3.10, Identify Sources and Types of Law. In Part 2, we focus on describing sources and types of law. Benchmark clarifications number 2 and number 3 are our focus. In benchmark clarification 2, students will recognize natural, constitutional, statutory case, and common law as sources of law. Benchmark clarification 3 asks students to compare civil, criminal, constitutional, and/or military types of law. What are the sources of law that have shaped the legal system, and what are the types of law that have influenced the development of the legal system in the United States? So we now look at 5 sources of law. The first of these is natural law. The concept of natural law is that all human beings are born with and entitled to life and liberty. We see these concepts highlighted in the U.S. Declaration of Independence, which focuses on the concept of natural rights and the social contract. We also note that this notion of natural rights means that people, just because they are born and for no other reason, are entitled to specific rights. And by being entitled to specific rights, this means that the government cannot take those rights away without due process, and the government must protect a person's right to their natural rights. With constitutional law, this is law based on interpreting the Constitution. This type of law is a situation where a court will decide what the Constitution means, and based on what the Constitution means, the precedent is set as to how that law will be enforced. So, for example, we see the Supremacy Clause as noted in Article 6 of the United States Constitution. The Supremacy Clause means that if there are 2 laws that conflict with each other, one being a state law, one being the national law, then there is no debate, no discussion, no court that's going to decide which of those laws is better or which of those laws is preferred. Rather, the Supremacy Clause states that if there is a conflict between a national law and a state law, then this national law will prevail, regardless of anyone's opinions about which law might be better. This approach promotes national unity. And so if a law is based on the Supremacy Clause, then that means that states cannot conflict with it, and a national law cannot conflict with the state law. What about statutory law? When we focus on statutory law, these are laws enacted by Congress or state legislatures. In essence, we're talking about statutes that have been passed by the national legislature, which is Congress or state legislatures, and enacted by the president or governor. So when we look at the Civil Rights Act and the Voting Rights Act, we're focusing on statutory laws. This means that this source of law comes from Congress writing bills, making sure that the bill from the House matches the bill from the Senate, the president looking at these two, at the bill that was passed and approved by both houses of Congress, and then the president deciding to enact this particular bill into law by signing it. Same goes for the Voting Rights Act. So this is very different. Think about who's making these laws. That if we're talking about constitutional law, we're talking about a requirement or rule in the U.S. Constitution. If we're talking about statutory law, we're talking about laws made by elected officials. Now we turn our attention to case law. When we're focusing on case law, we're focusing on court decisions based on precedent or judicial review. This means that the law itself is the case decision. And it's the case decision that then prevails, even if a law is found to be unconstitutional or if it's interpreted in a particular way. The court decision based on a particular law becomes the law. So let's look at Marbury versus Madison. Marbury versus Madison was a U.S. Supreme Court case that ultimately resulted in the development of what we call judicial review. Now, Marbury versus Madison included a law that focusing on the federal judiciary. In fact, the name of the law was the Federal Judiciary Act of 1789. But the Federal Judiciary Act included some language that contradicted the U.S. Constitution. And you'll be studying Marbury versus Madison in other parts of this course. But the important point here is that by the court looking at the Federal Judiciary Act, they decided that there was an element of that law. There was an element of that law that contradicted the Constitution, and thus the Supreme Court said what we say goes and not what the law decides. We decide what the law is when there is this conflict going on. And what about common law? Common law is laws based on customs and prior legal decisions that have been used in civil cases. So, for example, there have been many cases based on this custom that women should not be playing a role on juries, because if the expectation of women is that they are full-time homemakers, then they should not be pulled away from their homes in order to serve on juries. They shouldn't be pulled away from caring for their children in order to serve on juries. And so consequently, there are these different practices that denied women a right to sit on juries, even if the defendant was a woman herself. And so that's where we find this concept of common law. Now we're going to look at different types of law. There are different types of law that end up being based on the law, the basis for the laws. So the basis for the law plays a role in the development of the types of law. So first we begin with constitutional law. Constitutional law is laws based on interpreting the Constitution. So the example that we see here is the Voting Rights Act. The Voting Rights Act codified. Codified means created a law that had to then be implemented, the 15th Amendment. So even though the Voting Rights Act was put into place 95 years after the 15th Amendment, the 15th Amendment is just one or two sentences and says that no one can be denied the right to vote based on their race. But what exactly does that mean? What the Voting Rights Act did was it codified what the 15th Amendment means and talked about how people, because of their race, could not be given discriminatory literacy tests, that they could not be given different standards for voter registration, and other kinds of factors. So that's what the Voting Rights Act did. It took the constitutional basis for no voting rights discrimination based on race and then provided the language and the text for what that means. What about civil law? Civil law is law based on the relationships between people. So Article 1, Section 8, which includes 18 different clauses, one of the clauses in Article Section 8 protects copyrights and patents. These are creative works produced by individuals. This means that if I produce something and I can put my name on it, that belongs to me. Somebody else cannot take my written work. If I were to write a wonderful poem, for example, they can't copy that poem and then publish the poem and try to get royalties from the publisher. It's my poem. It's my work. And so consequently, civil law affects these relationships, because if somebody were to take my my creative work from me, they can't expect that I'm going to do nothing about it. So consequently, our relationship is affected. What about criminal law? Criminal law focuses on crime and punishment. So crimes against theft or murder that are prosecuted by the government. When a person is subject to a crime, if somebody has something stolen from them, or someone commits arson, which is using fire to destroy something, or steals a car, even though I might own that car, in addition to it being a crime against me, that's also a crime against the government because this person has violated the law. And so the government can prosecute the person who violated the law because the government is the victim. The government requires no stealing cars. Consequently, if somebody steals a car, then that means it's a crime against the government and then can be prosecuted by the government. What about juvenile law? Juvenile law is laws focusing on persons under age 18. And juvenile law also focuses on laws violated by persons under age 18. So juveniles who commit certain crimes are sentenced, for example, to juvenile detention rather than prison. Sometimes it happens where a jury or a judge might decide to prosecute a juvenile as an adult. What this means is they can be subjected to prison, they could be subjected to longer sentences than they would be had they been prosecuted and treated as a juvenile or treated as a child. Or it might also mean, in the most extreme circumstances, whether or not that person can be executed for their crime. Because right now, a person cannot be executed for a crime that they commit if they are a child. But if a judge or a jury decides to prosecute a case as if that child is an adult, then that means that child might then end up being executed for a particularly heinous or a horrible crime. What about military law? Military law is laws applying to persons in the military because persons in the military must abide by the Universal Code of Military Justice. This means that there are some crimes that if they were committed outside the military by a civilian, then they might end up receiving a lesser punishment or no punishment at all. Whereas in the military, there are certain crimes that there's a way of prosecuting and a way of reporting, and thus there is going to be a different type of punishment for those people who are found guilty of violating the Universal Code of Military Justice. Thank you for joining me for Middle School Civics Highlights. Do you still have questions? If so, please contact us using the information that appears on the screen. Till next time, I'm Dr. Terry Susan Fine. Thank you for joining me.